Welcome back to Financial Literacy for Lawyers, Bridging Law and Business. I'm Professor Seth C. Oranburg, and this episode explores how financial distress turns legal, when bankruptcy becomes not just a financial event, but a site for legal strategy. And I'll talk about what every advisor should know about preference payments, fraudulent transfers, and the deepening insolvency doctrine. If you're seeing your client in financial distress, you need to have a roadmap, and I'll help equip you to act early. Remember, we're building on statements that we've already covered, so I hope you don't feel overwhelmed because you probably know by now this is not about doing all the math, but having a really good conceptual understanding around what issues come up. And we're going to continue that in one of the most high stakes financial areas, bankruptcy. So, what is bankruptcy? Bankruptcy is not just about giving up. It's about resetting the balance between creditors and borrowers under a detailed legal framework, which allows for a reorganization or a liquidation, which protects some remaining value. When a business declares bankruptcy, whether under Chapter 7 for liquidation, selling assets to pay debts, or Chapter 11 for reorganization, the idea is to keep operations going while restructuring. And as you may recall from earlier episodes, if you keep operations going during restructuring and you are illiquid, you could be conducting illegal activities. So it's important that these provisions exist because they protect activities by the automatic stay. They halt most collection activities like lawsuits or foreclosures, and they provide more room to continue operations, which again can preserve value. The process requires detailed financial disclosures, schedules of assets and liabilities, and it opens the door to intense creditor scrutiny, with a trustee overseeing fairness. In Chapter 11, the debtor, often still in charge as the, quote, debtor in possession, the debtor functions as a fiduciary for the estate, proposing plans to reorganize or liquidate. The ultimate goal is an orderly wind down or restructure that retains viability, like negotiating a settlement in court, where creditors vote on plans so that the business can continue. Filing buys some breathing room, but demands some transparency. Sworn schedules become evidence, and U.S. trustees enforce compliance to prevent abuse. For lawyers bridging law and business, this resets priorities. Equity often gets wiped away, owners can lose their stake, and creditors take center stage with priority claims. And every pre-filing transaction gets reviewed for fairness. So understanding the framework helps advise on whether to file or whether to pursue alternatives like workouts. So one thing people don't realize is that the triggers that could cause bankruptcy, they're not always obvious. So I want to bust the myth that you know when a company is going bust. Persistent negative cash flow, declining liquidity ratios, growing debt loads, and failures to meet obligations, those are all numeric alarms for potential bankruptcy. A business's legal counsel is often the first to spot when liabilities overtake assets. This is the balance sheet insolvency test, tipping negative, where total debts exceed total resources. But there could also be cash flow insolvency, where bills can't be paid on time, despite asset value. For directors and advisors, recognizing these early is crucial, as delay exposes personal liability for wrongful trading, for continuing actions while insolvent, or for harming creditors. Signs include chronic negative operating cash, core businesses losing money, stretching payables, like vendors paid in 90 days versus 30, which can strain relationships, auditor notes about going concern, warnings about survival, or management's silence on forecast as they bury their heads in their sand and avoid bad news. In the 2023 Signature Bank failure, they ignored liquidity strains from deposit runs. Cash outflows were exceeding inflows, so there's a liquidity crisis. And this led to the feds actually seizing the bank and the executives facing suits for fiduciary breaches over inadequate risk monitoring. The bank, which focused on crypto and real estate, lost $10 billion in deposits within hours on March 10, 2023, leading to FDIC takeover on March 12th. Ongoing lawsuits allege directors ignored warnings about concentration risks. If two signs align, convene a distress huddle. Finance, legal, and advisors should get together to map options before filing becomes inevitable or impossible, which could potentially save value by having negotiations before you have no choice. Bankruptcy law overall strives to treat creditors fairly. So let's talk a little bit about some of the doctrines that attempt to do this. The first is the fraudulent conveyance doctrine. This involves a transfer that hinders creditors because there's been a transfer of a distressed company's assets for less than its value while it's insolvent. And the thing is, this is all determined with hindsight, and value would be fair market value. Courts can examine if assets were shuffled to insiders or to affiliates, often using badges like inadequate consideration or timing your distress to flag these as fraudulent conveyances. Defenses can include ordinary course payments, routine business defense, or contemporaneous value exchanges. But if you are in a situation where you're insolvent, you are subject to much greater scrutiny on any deals, particularly those that could involve insiders, because bankruptcy law exists to treat creditors fairly. The deepening insolvency doctrine refers to actions worsening a company's situation post-insolvency, like taking on new debts or loss-making asset sales that increase losses. While it's not always a standalone tort or a claim for damages, it can be evidence of damages in fiduciary claims. Now, this varies by jurisdiction, but some recognize it as a harm to the entity, others as aggravating breaches. And in any case, if you're in a position of insolvency, taking actions that make it worse can lead to greater liability and greater damages. Directors risk liability if post-insolvency moves erode recoveries. So if they continue unprofitable operations without plans, that can mean personal liability for them, which means the best practices are to cease preferences once insolvency looms, seek advice on operations versus filing to show diligence. In Quadrant Structured Products versus Verton, a 2014 case, creditors sued over risky bets that they said squandered value. Though the directors eventually won on a finding of no continuous insolvency, the case stressed how duties shift to creditors in times of distress, requiring maximization for all stakeholders, not just for stockholders. To navigate distress effectively, here's some guidance with a few implementation notes. The first is to run cash flow forecast routinely to project inflows and outflows. The key point to take away at this stage is if a company is in a position where it is in the zone of insolvency, it's absolutely crucial to talk to a bankruptcy attorney about whether or not risks have shifted to creditors who now might have fiduciary duties against the directors. And so now I hope that you're empowered as an attorney who may not be a bankruptcy expert to have some sense of how the financials speak to this issue. In our final episode, we're going to tie it all together with a discussion about the skills we developed this season. We'll explore how our financial fluency will empower us to protect clients even through the toughest downturns. And we'll even think a little bit about how this newfound skill can help advance your career. You know, bankruptcy numbers turn into strategies. We can use them to bridge law and business resilience. And we can think about this strategically as we move into our final episode. But until then, I'm Professor Seth C. Oranburg, and this has been Organized.